Hi, we are Cynthia Castro, Gabriela Velasco, and Karen Maldonado, students of International Relations at Tec de Monterrey Campus Querétaro. We're part of the semester 2021 CAPS in the dispute settlement module guided by Robert Harmson, and the importance of this informative video is to present two of some of the mechanisms used in peaceful settlement of disputes. First of all, it is crucial for a better understanding of the topic to examine a concise introduction of what is peaceful settlement of disputes and its relationship with international relations. Secondly, a broad explanation of negotiation processes will be discussed. Thirdly, a brief analytical comparison between good offices and the arbitration will be examined, and finally, a conclusion of the aforementioned will be reviewed. Hobbes understood the human state of nature as violent, even though he thought that individuals most of the time are looking for peace. When peace is not an option, our nature is war. Kant also used to believe that human nature apparently was not that good. States were always threatened and would seek to arm themselves and defend their interests. The situation could only be overcome with international law. With successes or errors in their perceptions, the reality is that conflict, disputes, disagreements, and tensions are part of the international panorama and context, and it is up to international relations to study and theorize about the interactions of the states and actors involved in the construction of the globalized and interdependent world. Consequently, when positive peace ceases, it is the responsibility of the international organizations, actors, parties, and academics to devise tools and mechanisms of action that help prevent the controversy from escalating into a conflict or make the conflict even worse. Besides, it is also an obligation of the states, parties, or individuals involved in the controversy to pick or decide the most proper peaceful mechanism to help them solve their dispute. Now, starting the explanation, the peaceful settlement of disputes is a key principle in international law, and according to Zavala 2017, its nature is of a peremptory character. This means that the nature of the peaceful settlement of disputes is an imperative norm known as well as an jus cogens norm. Thus, it is accepted and recognized by the states as part of the international community. This information could be seen in the Vienna Convention in Articles 53, 64, and 71, for example, but for the purposes of this informative video, it will be orientated with the topic of matter, which is a PSD. In accordance with the above, in the United Nations Charter in the Chapter 1 of the Purposes and Principles, Article 1, Paragraph 1, it is mentioned that one of the main objectives of the United Nations is to bring about by peaceful means, in conformity with the principles of international law and justice, adjustment or settlement of international disputes or situations which might lead to a breach of the peace. Also, the PSD is in conformity with Article 2, Paragraph 3 of the UN Charter, which states that all members shall settle their international disputes by peaceful means in such manner that international peace and security, justice are not endangered. It is also related with Article 33 of the United Nations Charter, Chapter 6, which says that states would pursue a solution for their disputes by mechanisms as negotiation, mediation, inquiry, conciliation, arbitration, judicial settlements, resort of regional agencies or arrangements, or other peaceful means of their own choice. This PSD issue is also stated in the following legal sources, which are gonna be appearing in the screen, but for mentioning some of them are the Vienna Convention of the Law of Treaties, the OAS Charter, the Pact of Bogota, so on.
Negotiations are the first instance that parties consider in any dispute settlement process. Any matter that is bilateral or multilateral and where the interested parties are directly involved in voluntary discussions as means to dispute settlement is considered a negotiation. Negotiations are settled in many different parts of the international law. For example, in the United Nations Charter, Chapter number 6, it states that the parties to any dispute, the continuance of which is likely endanger the maintenance of international peace and security, shall, and this is the important part, first of all, seek a solution by negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement, resort to any regional agencies or arrangements, or other peaceful means of their own choice. It is important also for the principle of seeking solutions through pacific means. For example, in the Pact of Bogota, Article number 1, it states that the high contracting parties must reaffirm their commitments to the other international conventions and declarations, as well as to the mentioned Charter of the United Nations, and, the important part, agree to refrain from the threat of the use of force. For this reason, in any other means of coercion should be avoided as well, and they have their recourse at all times to pacific procedures. And the first pacific procedure to which most parties or states recur in a dispute is precisely negotiation. Also, according to the OLA Handbook, Article number 28, many treaties, including the obligation to carry out negotiations, consultations, or exchanges of views whenever a controversy emerges, and specifically when they have a connection with the specific treaty. Some of these examples are the 1982 United Nations Convention to the Law of the Sea, specifically in Art number 283 in paragraph 1, and in 1975 in the Vienna Convention on the Representation of States in the Relations with the International Organizations of the Universal Character. This means that whenever there is a controversy on, for example, the use or interpretation of the law of the sea, uh, negotiation can be recurred as a first term.
According to the General Assembly Resolution of 1970, Article 2 establishes that states should accordingly seek early and just settlement of their international disputes by negotiations, inquiry, mediation, conciliation, arbitration, judicial settlement, resort to regional agencies or arrangements, or other peaceful means of their choice. On the other hand, and as one of the main characteristics of negotiations, the Manila Declaration on the Peaceful Settlement of International Disputes highlights flexibility as one of the characteristics of direct negotiation as a means of peaceful settlement of disputes. Negotiation is a flexible means of peaceful settlement of disputes in several respects. It can be applied to all kinds of disputes, whether political, legal, or technical. At the same time, the Manila Declaration highlights the effectiveness of negotiation. Negotiation as one of the means of peaceful settlement of disputes is most often resorted by states for solving continuous issues, and that, while it is not always successful, it does solve the majority of disputes. United Nations Office of Legal Affairs establishes an initial phase of negotiation, where the negotiating process starts as the result of one state perceiving the existence of a dispute and inviting another state to enter into negotiations for its settlement. The setting in motion of this negotiation process can be encouraged by international organizations. As an example of this, the Security Council has on a number of occasions adopted resolutions calling upon states to enter into negotiations. The duration of the negotiation process varies according to the circumstances. The process may be concluded in a few days or may be extended over several decades. Referring to the outcome of negotiations and possible subsequent steps, when negotiations are successful, they normally lead to the issuance by the parties of an instrument by reflecting the terms of the agreement arrived at. If negotiations are unsuccessful, the parties may choose to adjourn the negotiation process, sine die, or to issue a communique recording the failure of the negotiations. As part of the legal resources, the International Court of Justice stated that the obligation to negotiate thus flows from the very nature of the respective rights of the parties. To direct them to negotiate is therefore a proper exercise of the judicial function in this case. This also corresponds to the principles and provision of the Charter of the United Nations concerning peaceful settlements of disputes.
Talking about good offices, the definition I would suggest is that this concept is also known as an informal meetings, and it's a diplomatic mechanism of the peace settlement of disputes in which a third party intervenes by offering itself as a friendly intermediary. This is either by its own initiative or upon the request and consent of the parties in dispute. It means that the third party in the exercise of the good office helps to facilitate efforts to further negotiations, rendering a channel of communication with the objective of ending the existing controversy between the dispute parties without necessarily offering solutions or suggestions. In addition, for Javier Pérez de Collar, good offices are basically a quiet diplomacy, whereas for Boutros Ghali it is any diplomatic action taken to prevent disputes from arising between parties or to prevent existing disputes from escalating into conflicts and limit the spread of the latter when they occur. Now, the main characteristics of good offices are that both consents of the parties involved are needed to follow good offices as a peace settlement mechanism. States shall seek the resolution of their controversy in bona fide and following the spirit of cooperation. The third party involved in the good office could be a single state, a group of states, an individual as the UN Secretary General, for example, specialist agencies, or international and regional organizations, as long as they are not involved in the dispute, of course. The third party must be objective, impartial, neutral, and trustworthy. The intermediary should always maintain confidentiality and with the ability to resume a favorable context of negotiation, thus providing a proper channel of communication. In accordance with the 1899 and 1907 Hague Conventions for Pacific Settlement of International Disputes, states shall consider good offices or mediation before appealing to arms. This is in accordance with the principle of no use of force. Also, friendly powers are allowed to intervene exercising good offices or mediation even during the hostilities. It means that even the parties are in constant dispute, friendly powers shall intervene. Also, good offices follow discrete actions aimed to initiate direct negotiations between the litigant parties following a passive role, proving the virtues of solution and the importance of mutual compromise. Nevertheless, sometimes the exercise of good offices link with mediation, and the third party is allowed to take an active role by holding meetings or proposing solutions. As it is a flexible mechanism of dispute settlement, the litigant parties should seek by their own their final solution or decision by peaceful means. The parties in dispute remain in control of their possible outcome. In no scenario does any party reinforce the idea of the use of force. It is kind of prohibited. Also, good officers do not usually meet jointly with the parties in dispute. They meet separately with each of them. However, if it happens, it is negotiated with a mediator. The good offices can be finished in two possible ways: when the parties resume the direct negotiations, or when the third party does not succeed to create a positive ambience and communication between the opposing parties and the negotiations cannot be resumed. Nevertheless, it is stated in the Pact of Bogota that once the parties reach direct negotiations, good officers could be present at the negotiation table if all of the litigant parties agree with it. According to the institutional aspects, commonly when direct negotiations cease or progress and the parties in dispute cannot reach an agreement, the good officers become a viable option. Initiation of the procedure. It commences at any time after a request of consultations. Any party involved in a dispute can submit a petition to the Director General for the application of mechanisms as good offices, conciliation, or mediation. The third party disposed to exercise good offices may be friendly and in bona fide offers to cooperate. Otherwise, it can be requested by both parties in dispute, and in no way a good office can impose itself. According to the Pacta Sunt Servanda, it means that the exercise of good offices can be applied or implemented in accordance with an international obligation that recognizes an applicable treaty between the states in the dispute, or an ad hoc manner, for example. For giving a brief and vague explanatory of this, if Mexico and Colombia recognize the UN Charter and Hague Conventions, or maybe the OAS conventions, because they recognize this, it is applicable for both of them, and then they have obligation to accomplish the purposes and objectives of those treaties. That is the Pacta Sunt Servanda principle. According to methods of work and venue, the third party exercising good office contracts by informal meetings to each of the states in dispute. Then the one in charge of exercising the good office ascertains the position of both sides in the dispute to transmit it later to them, always with a friend will, avoiding disrespect anybody. In case of shuttle diplomacy, when the communication channel is limited or it's broken, the third party in charge of the good offices can visit the capitals of the parties in dispute, or even the third in question can request to each of the parties involved in a dispute to send their representatives separately or jointly, and they can meet in the United Nations headquarters. A process that has been terminated may be restarted at any time by the request of the parties. The considerations of the previous paragraph is regarding the mutatis mutandis, which is making the necessary changes. And also, it is stated that ex parte communications are permitted, which is that all communications made during the process shall remain confidential and shall not be revealed at any time. An example of all this process of good offices could be the United States and the European Community's dispute over a tariff treatment of citrus products in 1982. Regarding to outcomes, positive outcomes. If good offices end up being successful, conflict can be prevented or the escalation of tensions and risk that undermine international security and peace can be avoided. And even though violence cannot be properly measurable, active violence can be omitted or its negative impact reduced. Also, the dispute parties maintain control of the process and the expected outcome, which is a more flexible way of achieving a solution of a dispute. Another positive outcome would say that the persuasion and tact are general mechanisms and often lead to healthier relations rather than the use of mechanisms which use a compulsory element. Nevertheless, it happens that good offices tend to have a negative outcome, which can be, for example, the reach of a dead end in which one of the parties in dispute does not want to participate in the opening of negotiations. Also, the risk of break the communication channel and fall into this shuttle diplomacy. Another negative outcome would be that since the states have freedom of choice and faculty to manifest their interest, sometimes the process guided by good officers resist a peaceful outcome due to the parties' voluntarism and their accommodation of power. According to Cansado, both parties can refuse to create a neutral and positive environment in communication. Also, it is important to mention that the consent, even though it refers to sovereignty and the will of the states to permit the intervention of a third party, it doesn't mean that the Security Council can do or can exercise its investigatory power over the situation. However, in accordance with the legal framework, the jurisprudence used was the Vienna Convention of the Law of Treaties that affirms that disputes concerning treaties like other international disputes should be settled by peaceful means. The UN Charter, mainly Article 33, Article 1, and Article 2. The Manila Declaration, which states that dispute settlement would be in good faith and with a spirit of cooperation. Also, the 1983 International Coffee Agreement, the Article 57, which established that the course of the consultation process on request by either party and with the consent of other, an independent panel shall be established which shall use its good offices with a view of conciliating the parties. Also, it was used the UN General Assembly Resolution 4351, which states that the Security Council should consider sending at an early stage fact-finding or good offices missions for establishing an appropriate forms of presence, including, for example, observers, peacekeepers, preventing the further deterioration of the dispute or situation in the areas concerned. It is also used the Hague Conventions for the Pacific Settlement of International Disputes, the Article 2, which states that in case of serious disagreement or conflict before an appeal to arms, the signatory powers agree to have recurs as far as circumstances allow the good offices or mediation of one or more friendly powers, the Article 3, Article 6, Article 8. Also, it was used the Pact of Bogota, Chapter 2 of Procedures of Good Offices and Mediation, Article 9 and Article 10. The Charter of the Organization of American States, OAS, Chapter 5 of Pacific Settlement of Disputes in the Articles 24, 25, 26, 27, and the 1988 Declaration of the Prevention and Removal of Disputes and Situations which may threaten international peace and security, and on the role of the United Nations in this field, that also provides in this paragraph 12 that the Security Council should consider sending at an early stage fact-finding or good officers missions or establishing appropriate forms of United Nations presence, including observers and peacekeeping operations, as a means of preventing the further deterioration of the dispute or situation in the areas concerned.
Now, we will talk about arbitration as a legal method. Arbitration is a procedure that serves as means for dispute settlement among parties and results in binding decisions, which is the important part. State parties voluntarily agree to arbitration either before or after a dispute has arisen, before it can be in any agreement or in a special agreement. State parties have a sense of control over the process as they have a say on the selection of the arbitrators that will regulate the dispute settlement process. Arbitration is used generally to solve disputes such as territorial and boundary disputes, but also violation of international law and interpretation of multilateral treaties. In expert words, international arbitration is a specially established mechanism for the final and binding determination of disputes concerning a contractual or other relationship with an international element by independent arbitrations in accordance with procedures, structures, and substantive legal or non-legal standards chosen directly or indirectly by the parties, by Liu, Mistels, and Kroll. Now, we will discuss the main characteristics of this method. Arbitration is a compulsory means of the dispute settlement. This means that the results that it has have a direct effect on the different parties. It also must be implemented by mutual consent of the parties that submit to the process. Without consent, it cannot be implemented. Also, parties have the power to choose their arbitrators, which is a complicated process that will be later deep on, but still it gives a sense of power over the control of the arbitration process to the different parties involved in the dispute settlement. Also, there exists a permanent court of arbitration, abbreviated as PCA, that is an intergovernmental organization which was established in the year 1899 in the Convention of the Pacific Settlement of International Dispute. And this organization helps mainly for the administrative help for the arbitration process, specifically for the selection of the arbiters, which is sometimes complicated if the parties are not getting along in their decisions. Also, the arbitral tribunal that is composed on the process of arbitration may be composed from 1 to 5 members. 3 is the most usual practice of numbers, and usually there are odd numbers preferred as they can settle disputes among the arbiters. Also, the arbitration process is a very formal process which has a specific procedure to be followed, which will be explained later on. But however, the formal means give it a lot of effectiveness in the process, and for this reason, as it has definite outcomes that have a binding effect on the parties. However, the arbitration process ends.
Arbitration as a third-party procedure may be performed by one individual, appointed by the parties to the dispute, as a sole arbitrator or by a group of individuals appointed to form an arbitrary tribunal. Arbitration and judicial settlement are employed when what is wanted is a binding decision, usually on the basis of international law, and hence these are known as legal means of settlement. Arbitration may be prescribed in a treaty providing for its use in the event of dispute relating to the interpretation or application of the agreement, or arranged by the parties when a dispute arises.
In order to explain the application of the method, some of the rules for arbitration have to be explained. For this section, we will refer to the Model Rules on Arbitral Procedure from 1958. The main ones are related to the legal obligation that is carried out by each of the party, that they have only to carry away out of good faith. And that means that if the parties decide voluntarily to get into the process, then after the outcomes come out, they must obey the results by the arbitration process in good faith as they subjected to this law. Also, it is important to state that this process may be applied to either existing or new disputes. Some treaties or parties may apply that they would use arbitration if a dispute in any specific matter emerged within a treaty, or when a dispute arises, they can agree to go into an arbitration process. Also, for the process to be valid, it has to be embodied within a written instrument for the validity of the process. And as the states are involved in this type of process, it is compulsory only if the states previously agreed to its compulsory terms, for example, in a compromise or in another kind of settlement. And finally, there has to be this idea that the parties participating are equal on, to the eyes of the arbitral tribunal. This for the outcome to be a just one. And now we will further explain the process that happens when arbitration goes on. First, a dispute has to exist, and all the parties involved must acknowledge such dispute for the dispute settlement to occur. If there is no dispute, there cannot be any dispute settlement process. Also, at least one of the states involved must submit a request for arbitration, and the parties in dispute must voluntarily accept this arbitration procedure. As to say that one party must ask for the arbitration, and the rest of the parties involved must accept such procedure for it to occur. The parties must also appoint their preferred arbitrators, and the arbitral tribunal must be constituted. This means that they can select from the list of arbitrators that exist their favorite ones in order, and if it coincides with the ones of the other side, those are the ones that are going to be selected. If not, there occurs a very complicated process on how to select the specific judges that will be part of the arbitration process. Once the proceedings begin and the arbitral tribunal is confirmed, it must evaluate its own competence over the subject matter, as to say if they have the ability to have a resolution or they don't. It must take into account several parts of law, as we must remember that this is a procedure of law and not diplomacy, and as such it should take into account compromise, if there is one, also international conventions, international customs, and judicial decisions that are prior to the arbitration process. Next, the parties shall appoint agents before the tribunal that represent them during the process. These agents will be the intermediaries between the parties and the tribunal, and will speak for their needs and their interests. Then the pleadings occur. During the pleadings, there is communication among the agents and arbitral tribunal, in which they state their interests and have conversations that are accompanied by all their cited documents. The next is a hearing, where agents expose their parties' arguments before the arbitral tribunal, And after these pleadings and hearings have occurred, the Arbitral Tribunal receives all the evidence and signs the valid documents, while rejects the documents that are not original or that are not considered valid for as proofs of the dispute, and it can proceed to ask for testimonies, experts, visits, or any other form of evidence that may contribute to complete the information for the settlement of the disputes, and the proceedings are declared closed after that. Also, the arbitral tribunal may reopen the proceedings if it considers it necessarily, but normally they are closed. Finally, the arbitral tribunal has secret deliberations in which all the members of the tribunal participate and show their input into the dispute and how it should be settled. And finally, the arbitral award is communicated to the agents of the parties, and it must be accompanied by the justification and the reasons for such award in order for them to be valid. And it terminates the dispute definitely and must be carried out in good faith by all parties, as was mentioned before. In case that some of the parties do not follow the award or dismiss their authority, the other party may also take it to the International Court of Justice, or may return to the arbitral tribunal to ask for help in order for the resolution to be taken away of.
Institutional aspects of arbitration are based on the types of arbitration agreements, where consent of the parties to arbitration may be expressed prior or after the occurrence of a dispute. Such commitment may be made in multilateral or bilateral treaties, entirely devoted to the peaceful settlement of disputes. A compromissory clause is a provision in a treaty which provides for the settlement by arbitration of all or part of the disputes which may arise in regard to the interpretation or application of the treaty. To submit a dispute to arbitration under a compromissory clause, the parties usually need to conclude a special agreement, a compromise. The compromise includes at least the undertaking to arbitrate, according to which the dispute is to be submitted to the arbitrators, the subject matter of the dispute, and if possible, the points on which the parties are not agreed, the method of consulting the tribunal and the number of arbitrators, the rules of procedure and method of work of the tribunal, the languages to be used, the applicable law, the seat and administrative aspects of the tribunal, the financial arrangements for the expenses of the tribunal. The outcome of an arbitration is an award, which is binding upon the parties to the dispute. The arbitral awards are usually in writing, signed, and dated. After an award has been rendered, it may be subject to correction or revision in connection with obvious errors, such as clerical, typographical, or arithmetical. The last stage of arbitration is the execution of the arbitral award. Depending upon the nature of the dispute in question, parties may include the compromise, the necessary steps to be taken towards the execution of the award.
Up until now, we have covered several of the aspects related to the arbitration method. However, now we will cover how it is treated among the international literature. For example, starting with the Vienna Convention of the Law of Treaties, we can see that in Article 66, it states that if no solution has been reached when there is a controversy between the states within a period of 12 months after the objection, then the parties or any party can access to the International Court of Justice for a decision unless the parties, by common consent, agree to submit the dispute to arbitration. In this sense, arbitration is seen as the better option towards the International Court of Justice, as it allows the different parties to have a say in what judges or what people are going to be arbitrating the process, and it is seen as a more peaceful process that is still a legal method. On the other hand, on Article 33 of the UN Charter, we can see that word by word it says the parties to any dispute the continuance of which is likely to endanger the maintenance of international peace and security shall first of all seek a solution by negotiation, as we have previously recalled when we talked about negotiation, inquiry, mediation, conciliation, and arbitration, which is why in the Article 33 of the UN Charter it is stated as an option for the settlement of disputes. Meanwhile, in the Manila Declaration, in Part 1, Paragraph 5, the list of the means to solve any dispute among the different countries is again stated, including negotiation, inquiry, conciliation, mediation, and arbitration as the different methods. Deepening more into the international conventions, in the Hague Conventions for the Pacific Settlement of the International Disputes, we can find several articles that are very interesting. For example, in Article 15, we can see that it states that the object the settlement of differences between states by judges of their own choice and a basis for the respect of law. This is what we've been talking about, of how the different states have the possibility of choosing their own arbiters uh, despite other legal processes and diplomatic. Also, in Article 16, we have a very important allusion, as it says that this procedure is usually applied to issues of interpretation or application of international conventions, and that's why arbitration is considered by the signatory powers as the most effective and at the same time most equitable means of settling disputes, which is what the diplomacy has failed to settle. This means that in comparison with other methods, such as the good offices that we have already discussed and seen that it has a lot of good qualities, it yet is not as effective as this method, and also this is the most equitable method within the legal methods. And passing to the Pact of Bogota, which in Chapter 5, Procedure of Arbitration, states the different aspects of the procedure of arbitration, is really interesting because it provides a lot of information as to how the process of arbitration is done and how the different parts of it proceed. For example, in Article 40, number 1, it states the procedure to choose the arbiters that will form the arbitral tribunal. And just to set an example, it says that within a period of 2 months after the parties have decided to go into arbitration, they should name some of the arbiters that they consider applicable for the process. And in case that they are the same, they are selected as the three arbiters, for example. But if they are different, there are different procedures that go on, such as the arbiters deciding on the third one, or if there are no names in common, then another process proceeds. So we will not depend into that, but it is important to mention that in this part of the law we can find the different aspects to the different cases that may occur. Also, it is very important that in Article 42, it states that when more than two states are involved in the same controversy and they stand for the same arguments, they are considered to have the same interests and they are considered thus as a single party. So when there may be more than two states involved in a conflict, and however, they may be only two parties. Finally, it also states in Article 46 that whenever there are dissenting arbiters, especially in the secret discussions, the dissenting arbiters have the right to show the reasons for their dissent, and thus can have like an individual opinion on the matter. Finally, on the Charter of the Organization of the American States, OAS, in Chapter 5, in the Pacific Settlement of Disputes from Article 24 to 27, we can also see the treatment that this charter gives to the arbitration. For example, it first states in Article 25 that the peaceful procedures are direct negotiation, good offices, mediation, investigation, and including arbitration. And in Article 26, it talks on how when there are disputes between the American states, which is the reason why it is included in the Charter of the Organization of American States, the opinion of one of them cannot be settled through the usual diplomatic channels. If this occurs, then there can be other peaceful procedures. By this, we can understand, going back to Article 25, that if the usual diplomatic channel, such as good offices, for example, is not working correctly or does not succeed at impeding the dispute to continue or to move into violence, then other peaceful procedures, such as arbitration, which is a peaceful procedure yet not a diplomatic procedure, can enable them to reach a solution. And as we have seen in the different documents, that arbitration is a quite effective method, then we could conclude that it could be a good option for the dispute to be resolved. By now, we have studied the different advantages and the disadvantages and the processes that involve both peaceful procedures, both the good offices and legal arbitration. Now we're going to expose our team's input on what the advantages and disadvantages of each of the methods are and how they can serve or not serve to a specific case. Starting with the diplomatic method of good offices, we have that it is a peaceful beginning for dispute settlement. By this we mean that it allows to manage the beginning of a dispute settlement solutions through peaceful means and avoids escalating them through violence. So it is a good start for a negotiation or for solving a problem. It is also very flexible, and by this we mean that there is no necessity for the case to adapt to the process, but the process can adapt to the case. In contrast, in the arbitration, the case must follow the rules of the arbitration process. So this flexibility happens when the negotiation allows the process of good offices to adapt to the specific case. And that is a very positive aspect because it allows for effectiveness in the sense that it accomplishes the necessities of the specific case. Also, the existence of an intermediary is a good aspect, as having a third party involved in the negotiations facilitates initiating conversations towards solving the disputes. Whereas somehow if the parties were alone and did not have the intermediary, probably they would just start going through violence. Also, this method is not imposing, and this promotes the different parts to follow their interests in an easier way, and it is multiple parties may agree to negotiations, and also at the same time satisfy their interests without having to follow the impositions of a third party or of an arbitrator. And finally, these are based on goodwill, since parties are voluntarily participating. A positive outcome for all involved is most likely. If they all want to, in a genuine way, have a peaceful settlement of disputes, it is easier to get to that. On the other hand, we have the legal arbitration. So in this method, we can see something really positive, that is that parties have a participation even if they are not the ones taking the decisions. By this we mean that they have a say on who forms the arbitral tribunal and thus can choose if they agree with the opposing parties or not on who are making the decisions. They can uh, kind of vote, but not vote, so just select their preferred selection of arbiters, and that gives them a sense of participation within the process. Also, the fact that this is legally binding is a very positive aspect as it has actual solutions and consequences for the parties after the award is given, which talks about a lot of the efficiency of this process. Also, the fact that it is based on a solid legal basis is really good, as legal methods, including the judicial settlement and arbitration, which is what we're talking about, take in consideration international law when making decisions, and this concern involve parties, but in this sense, it can be considered to be a more objective method, as the parties involved will have a resolution that is based on a legal method on what has been established in international law, international custom, and in this sense, it is a more objective method. And finally, formality is another positive aspect because the formality of this process and the protocols that it follows promotes its effectiveness in solving disputes as well it is legally binding. So all of the advantages of both the good offices and good and arbitrations make both processes be good in their own way, and they can be better for a specific case depending on the characteristics and the necessities of the dispute at the time. And finally, now that we've seen the bright side of both procedures, we will see the dark side on the disadvantages that they will have because they have them. On the first side, on the good offices, we can see that the decision making is not an is a disadvantage because the good officer cannot offer the solution for the problem. They can only participate in a way that is not binding, and that is not uh, giving a real solution to the problem. It is only opening the conversations about it, so it is not as effective as the arbitration process. Also, as it is not legally binding, it does not give a definite solution to the dispute, and if it does not succeed and peaceful means are dismissed, well then violent conflict may begin. So it is quite dangerous if it is not well done, because it is uh, very possible that it will, if failing, it will lead to violence. And finally, as the good officer plays a very passive role, they have an impact that is very limited on the process, and thus the effectiveness of the process is very limited as well. But on the other hand, it is also different in case with the arbitration, because arbitration passes through a lot of bureaucracy, which as this process during the arbitration may be complicated and require a lot of time, such as for example, just for the selection of the arbitral tribunal, then all the bureaucracy involved in the process makes it timely and complicated for the solution to come in an easy way or in a quick way. Also, it is important to consider that this process has a monetary cost, as all members of the tribunal must receive monetary retribution, and the process has a cost that the governments of the parties must cover. So it is also not for free. It has a monetary cost, and for example, if during the process some experts are required, or a trip or a visit to a specific place is required as well, the cost increases, so it can be costly for the different parties to get involved in these kind of processes. And finally, the lack of goodwill when submitting to this process. Usually parties enter a legal method when a diplomatic method have failed. For example, um, if the good offices method has failed, or maybe it didn't fail, but it did not succeed at completing a dispute settlement state, then there are no goodwills and satisfying the other interests, and processes are more complex when getting into arbitration. So these are some of the facts that complicate each of the processes. However, they must both be analyzed, and the most reliable one should be chosen on depending on the specific case and the specific conditions of the different parties or the different states that are taking place in this dispute. In conclusion, there is not a perfect method for peaceful settlement of disputes. The best one must be selected for each specific case, and a combination of them can also be implemented. Both diplomatic and legal methods provide alternatives that can lead to a peaceful resolution of disputes among parties. However, they differ in the means to succeed at it. While diplomatic methods use negotiation in its different forms to accomplish a peaceful resolution of problems, legal methods appeal to international law and give definite solutions that have real consequences on the parties involved.
As a conclusion, on the first hand, good offices offers a more flexible mechanism of a peaceful settlement. It maintains a passive role by opening the channel for apparently better communication, thus better negotiation. Nevertheless, it does not have enough scope to approach an active role that permits a third party to join the process of decision making, and if it does, it is currently related with mediation. It means that the third party has not permitted to offer any solutions, and it acts as a friendly advisor following the principle of bona fide and running the risk of falling into shadow activities with no longer capable to embrace the opportunity to negotiate more. This represents a serious pitfall and a risk to achieve peace and security. Even though states are obligated to reach for the solution of their disputes in a peaceful manner, the same UN principles state for respect of their sovereignty and subsequently the will of choosing to cooperate or desist from the provided help.
However, if the parties involved have goodwill for solving the dispute, they may opt for the diplomatic procedures at first instead. Both methods, diplomatic and legal, um, good offices, and arbitration, provide good alternatives for the peaceful solving of dispute settlement. However, the correct one must be chosen for the specific case and taking into consideration the specific necessities of the parties and their ability to solve their own problems. In dispute settlement, there is no one correct way of doing things, and there must be consideration to all the alternatives and all the possibilities that there exist, just maintaining in mind that the peaceful settlement of the dispute is a priority.